Section 12. List of authorities and addresses to content. 1. The HONBLE, President of India, Head of the Republic. Rashtrapati Bhavan, New Delhi 110004. 2. The HONBLE, Prime Minister of India, Head of Government. Prime Minister Office, PMO, South Block, New Delhi 110011. 3. The Cabinet Secretary, Government of India, Administrative Head. Cabinet Secretariat, Rashtrapati Bhavan, New Delhi 110004. 4. The Union Home Secretary, Ministry of Home Affairs, MHA. For Cyber Trespass, National Security, North Block, New Delhi 110001. 5. The Secretary, Ministry of Electronics and Information Technology, MIETI. For Information Technology Act related matters, Electronics, Niketan 6, CGO Complex, Lodi Road, New Delhi 11003. 6. The Director General, Indian Computer Emergency Response Team, CERT-IN. For examination of data, sabotage, and device control related cyber incidents, Electronics, Niketan 6, CGO Complex, Lodi Road, New Delhi 11003. 7. The Secretary, Department of Telecommunications Licensing Authority. Sanchar Bhawan, 20 Ashoka Road, New Delhi 110001. 8. The Chairman, Telecom Regulatory Authority of India Sector Regulator. Mahanagar Doorsanchar Bhawan, J.L. Nehru Marg, New Delhi 110002. 9. The Chairman, Securities and Exchange Board of India. For Corporate Governance and Listed Entity Compliance, SEBI Bhavan, BKC, Mumbai 40051. 10. The Chief Executive's National Stock Exchange of India. Exchange Plaza C1, Block G, Bandra Kurla Complex, Bandra E, Mumbai 400051. 11. The Chief Executive's Bombay Stock Exchange. For listing compliance, Firoz Jijibhoi Towers, Dalal Street, Mumbai 40001. 12. The Governor, Reserve Bank of India. For Airtel Payments Bank and Financial Compliance Central Office Building, Shahid Bhagat Singh Road, Mumbai 40001. 13. The Secretary, Ministry of Corporate Affairs and Registrar of Companies, ROC. For Director Liability, Shastri Bhawan, Dr. Rajendra Prasad Road, New Delhi 110001. 14. The Commissioner, Central Consumer Protection Authority. For Unfair Trade Practices, Krishi Bhawan, New Delhi 110001. 15. And all other competent statutory authorities, having jurisdiction over the matters stated herein. This is the analysis of the case based on the provided documents. Global Legal Strategy and Case Architecture. 1. Executive Summary. Synopsis of the case. This case involves a formal grievance by a lawful subscriber, Ranjit Chaudhary, against Bharti Airtel Limited for documented digital trespass, unauthorized administrative control over a private mobile device, and the subsequent deletion of approximately 35 gigabytes of personal and professional data. The complainant alleges that Airtel used a forced application, Airtel Exclusive, to hijack hardware functions, such as disabling the clipboard and SIM2 slots, and triggered a remote system wipe during a forced setup process. Core grievances: digital trespass, unauthorized remote access and administrative control of a privately owned mobile device, data sabotage, destruction of 35 gigabytes of data which the respondent admits they cannot restore, service deficiency, persistent lack of indoor network coverage at the complainant's residence despite official claims that all services working fine, support blockade, intentional blocking of the complainant's ability to update profile details and access grievance redressal channels. Sought remedies. The complainant seeks the immediate removal of all administrative controls, technical restoration of the lost data if possible, and the legal compensation of 1 million Indian rupees, 10 lakhs, for data loss and professional harassment. Legal position statement. The actions of the respondent constitute a prima facie breach of the Information Technology Act, 2000, Sections 43 and 66 regarding unauthorized access and data damage, and the Consumer Protection Act, 2019. Furthermore, these actions are presented as direct violations of fundamental rights under Articles 14, 19, 21, and 300A of the Constitution of India, specifically regarding the right to privacy and protection against unauthorized deprivation of property. 2. Parties' antecedents and legal standing. 2.1. Profile of the complainant, aggrieved party. Asterisk identity. Ranjit Chaudhary, a lawful subscriber of Airtel services. Mobile, 9,266,438,588. Status, a consumer and professional whose livelihood and personal records were stored on the device. Model, 2312BPC51H. Impact, suffered irreversible loss of 35 gigabytes of data. professional harassment due to restricted device functionality, disabled clipboard/SIM2, and lack of essential connectivity. Evidence, valid subscription records, device IMEI details, and a trail of formal communications from February to March 2026. 2.2 Profile of the accused. Alleged offender. Asterisk identity. Bharti Airtel Limited, a major telecommunications service provider, TSP, and a listed entity. Legal status. A body corporate under the IT Act, and a service provider under the Consumer Protection Act and TRAI regulations. Responsibility. Failed to ensure data integrity, bypassed user consent through forced software, Airtel exclusive, and admitted to weak indoor coverage and the inability to restore deleted data. 2.3 Jurisdiction, locus standi, and maintainability. Locus standi. As the direct victim of data loss and the primary subscriber, the complainant has a clear right to seek redressal. Jurisdiction. The cause of action arose in Delhi, Dwarka, Balswa. The matter falls under the jurisdiction of the Consumer Disputes Redressal Commission, the adjudicating officer under the IT Act, Secretary, MIADY, and the High Court of Delhi, under Article 226 for constitutional violations. Maintainability. The case is maintainable as it involves a deficiency in service and unfair trade practices, where internal grievance machineries, nodal, appellate, have failed to provide an adequate remedy. 3. Chronology of events and factual matrix. Initial setup, February 2026. Complainant attempted to set up the Airtel exclusive application as mandated by the service terms for the specific device/plan. The 19th of February 2026. Formal cease and desist issued by the complainant after the application took administrative control, disabling the clipboard and SIM2 slot, effectively hijacking the hardware. The 23rd of February 2026. Notice of liability sent to Airtel, explicitly stating that failure to provide a technical rebuttal would constitute a legal admission of the trespass. The 26th of February 2026. Airtel network team replied, acknowledging indoor coverage issues, but failing to address the device hijacking. The 1st of March 2026. The appellate authority admitted to the unfortunate incident of data sabotage and confirmed weak indoor coverage. The 3rd of March 2026. Department of Telecommunications, DOT, acknowledged the grievance and forwarded it to Airtel for mandatory action. The 5th of March 2026. SEBI, via scores, registered the complaint against the listed entity. The 7th of March 2026. Final admission by Bharti Airtel, via email, confirming weak deep indoor coverage and the total wipe of 35 gigabytes of data, while claiming compensation is infeasible. Or, statement of legal issues, points for determination. Issue 1. Whether the mandatory installation of the Airtel exclusive application, which asserts administrative control over a privately owned device, constitutes digital trespass and unauthorized access under the Information Technology Act, 2000? Issue 2. Whether the remote deletion of 35 gigabytes of the complainant's personal and professional data during a forced setup process amounts to data sabotage and criminal breach of trust. Issue 3. Whether the restriction of hardware features, disabling SIM2 slot and clipboard functions, on a device purchased by the complainant constitutes an unfair trade practice and a violation of the right to property under Article 300A. Issue IV. Whether the respondent's failure to provide indoor network coverage, while simultaneously claiming all services working fine, constitutes a deficiency in service under the Consumer Protection Act, 2019. Issue VI. Whether the respondent is liable to pay exemplary damages for the irreversible loss of data and the professional harassment caused by the support blockade. 5. Statutory and regulatory framework. 5.1. Violations of Information Technology Act, 2000. Section 43. Penalty and compensation for damage to computer system, etc. Accessing or securing access to a computer system without permission. Section 66. Computer-related offenses, dishonest or fraudulent act referred to in Section 43. Section 66F. Cyber terrorism. Intent to threaten the unity or security by denying access to authorized persons, applicable if the data loss impacts national/professional functions. 5.2 Consumer Protection Act, 2019. Section 211. Deficiency in service. Inadequacy in the quality, nature, and manner of performance. Section 247. Unfair trade practice. Imposing any condition which is unreasonable or causes significant change in the rights of the consumer. 5.3 TRAI regulations and DOT guidelines. Quality of service, QoS standards. Violation of the mandate to provide consistent network coverage as per the license conditions. Telecom Consumers Protection Regulations. Failure to provide a transparent and effective grievance redressal mechanism. 5.4 Linkage to evidence. The respondent's email dated March 7, 2026, serves as a direct admission of both weak deep indoor coverage, regulatory failure, and the unfortunate incident of data wipe, statutory violation. 6. Constitutional mandates and violations. Article 14, right to equality. The respondent's arbitrary administrative control over the complainant's device, while other consumers using different plans or providers retain full autonomy over their property, constitutes discriminatory and arbitrary treatment by a dominant service provider. Article 19(1)(g), right to practice any profession. By disabling hardware features like the clipboard and SIM2 slot, and subsequently deleting 35 gigabytes of professional data, the respondent has directly interfered with the complainant's ability to conduct professional affairs and digital communication. Article 21, right to life and privacy. As established in K.S. Puttaswamy v. Union of India, the right to privacy includes data protection and digital autonomy. Unauthorized administrative control and data deletion by a TSP is a gross violation of the right to be let alone and the sanctity of personal digital space. Article 300A, right to property. A mobile handset and the data stored within it are the property of the purchaser. The respondent's forced Airtel exclusive lock-in and remote data wipe constitute an unauthorized deprivation of property without the authority of law. Corresponding duties of the state. Under Article 256, the state is mandated to ensure that private entities comply with the laws of the land. The failure of regulatory bodies to prevent such high-handedness by a TSP reflects a lapse in the state's protective obligations. 7. Entity role mapping and liability assignment. Bharti Airtel Limited, corporate entity, holds absolute liability for the actions of its Airtel exclusive software. The entity is responsible for the data sabotage admitted by its appellate authority. Appellate authority and nodal officer, internal governance. Assigned individual and professional liability for failing to rectify the device hijacking despite multiple notices, February 19th, February 23rd, and March 3rd, and for ultimately dismissing the damage as an unfortunate incident. Department of Telecommunications, DOT, and TRAI, regulators. Their role is defined by oversight responsibility. While they have acknowledged the grievance, their failure to compel the respondent to restore functionality or provide compensation highlights institutional negligence in protecting consumer rights. Vicarious liability. The board of directors and the CEO are vicariously liable for the systemic failure of their automated setup processes, which prioritize administrative control over user data integrity. Joint and several liability. Both the software developers of the Airtel exclusive app and the service provider Airtel are jointly liable for the technical flaws that led to the 35 gigabytes data wipe. 8. Applicable legal principles and jurisprudence. Doctrine of natural justice. Audi alteram partem. The respondent's decision to maintain administrative control and refuse compensation without a technical hearing or providing a rebuttal to the cease and desist notice violates the fundamental right to be heard. Principle of promissory estoppel. The complainant entered into a service agreement based on the promise of telecommunication services. The respondent is now estopped from unilaterally changing the terms by seizing hardware control, SIM2/clipboard, and destroying data, as the consumer relied on the service for professional use. Doctrine of proportionality. Even if a lock-in or Airtel exclusive setup is part of a commercial contract, the total wipe of 35 gigabytes of unrelated personal/professional data is a grossly disproportionate action for any administrative or security purpose. Strict liability and data management. As a body corporate handling sensitive digital access, Airtel is subject to a high standard of care. The admission that they cannot restore data they caused to be deleted triggers an absolute liability for the resulting professional and personal damages. Criminal law principles. Mens rea, guilty intent, evidenced by the support blockade and the persistent refusal to address the hardware hijacking despite multiple formal warnings. Actus reus, the act. The physical execution of the remote system wipe and the disabling of device features via the Airtel exclusive application. 9. Authoritative judicial precedents. 9.1 Binding precedents. Supreme Court of India. Justice K.S. Puttaswamy v. Union of India, 2017. Established that privacy is a fundamental right under Article 21. Any interference with digital data and device autonomy must meet the threefold test of legality, necessity, and proportionality. Lucknow Development Authority versus M.K. Gupta, 1994, expanded the definition of service under the Consumer Protection Act, establishing that harassment of a common man by public authorities or large corporations is socially abhorrent and warrants exemplary damages. Charan Singh versus Healing Touch Hospital, 2000, held that the quantification of damages must be commensurate with the loss suffered and the degree of suffering/harassment. 9.2 Persuasive precedents. High Court/tribunals. Vinit Kumar versus CBI, Bombay High Court, emphasized that unauthorized interception or access to digital communication/devices is a violation of the right to privacy, if not backed by strict legal procedure. Cyber Appellate Tribunal rulings on Section 43, IT Act. Multiple rulings have established that causing damage to data or unauthorized access by service providers, even during maintenance or setup, entitles the victim to compensation from the body corporate. 10. Evidence analysis and prima facie case strength. Documentary and digital evidence. Admission of data loss. The email from the appellate authority, dated March 1, 2026, and the final response, dated March 7, 2026, explicitly admit to the unfortunate incident of data wipe and state that the 35 gigabytes of data cannot be restored. Admission of service failure. Direct written admission by the respondent of weak, deep indoor coverage contradicts their automated system claims of all services working fine. Technical logs. Evidence of administrative control by the Airtel exclusive app on device model 2312BPC51H, showing the disabling of the clipboard and SIM2 slot. Admissibility and relevance. Under Section 65B of the Indian Evidence Act, the digital logs, email trails, and screenshots of the administrative control settings constitute primary admissible evidence of digital trespass and service deficiency. Prima facie case strength. The case is exceptionally strong due to the unrebutted cease and desist notice, February 19th, and the respondent's own written admissions. The burden of proof shifts to the respondent to explain why a commercial software was permitted to perform a destructive system-wide wipe. 11. Prayer de lage relief sought. Writ of mandamus. A direction to the regulatory authorities, TRAI, to compel the respondent to restore the complainant's device to its original factory state, free from Airtel exclusive administrative locks. Compensation for data loss. A claim for 1 million Indian rupees, 10 lakhs, for the loss of 35 gigabytes of irreplaceable professional and personal data, citing the respondent's admission of inability to restore. Injunction. An immediate order to stop the support blockade, allowing the complainant to update profile details and access standard grievance channels without restriction. Punitive damages. Seeking exemplary damages for unfair trade practices regarding the hardware hijacking, SIM2/clipboard, and for the mental agony caused by the support blockade. Network rectification. A directive to provide the promised indoor coverage or a specialized signal booster at the complainant's residence as per the service contract. 12. Risk assessment and strategic recommendations. Potential counterarguments. The respondent may argue that the Airtel exclusive terms were accepted by the user during the initial setup. However, unconscionable contracts, where a consumer has no bargaining power, are frequently struck down by Indian courts. Jurisdictional challenges. The respondent might attempt to move the matter to arbitration. The strategy should be to emphasize that consumer rights and constitutional violations, Articles 21 and 300A, cannot be waived by an arbitration clause in a standard form contract. Mitigation strategies. Preservation of evidence. Ensure all 50 pages of the dossier, including the March 7th admission, are notarized. Regulatory pressure. Continue the follow-up with SEBI, SCORES, and the President's Secretariat to ensure the listed entity status of the respondent remains under scrutiny for data integrity lapses. Next legal steps. 1. File a formal complaint before the District Consumer Disputes Redressal Commission for deficiency in service and unfair trade practice. 2. Simultaneously approach the adjudicating officer under the IT Act for compensation regarding unauthorized data destruction, Section 43. 3. If no technical resolution is provided within 15 days, consider a writ petition in the Delhi High Court, citing the violation of fundamental rights under Articles 21 and 300A. Structure of case. 1. Executive summary. 2. Parties' antecedents and legal standing. 3. Chronology of events and factual matrix. 4. Statement of legal issues. Points for determination. 5. Statutory and regulatory framework. 6. Constitutional mandates and violations. 7. Entity role mapping and liability assignment. 8. Applicable legal principles and jurisprudence. 9. Authoritative judicial precedents. 10. Evidence analysis and prima facie case strength. 11. Prayer/relief sought. 12. Risk assessment and strategic recommendations. Incident. Forced administrative control of private mobile device via Airtel exclusive app. Disabling of hardware functions, SIM2 slot, and clipboard/copy paste. Unauthorized remote system wipe resulting in the loss of 35 gigabytes of personal/professional data. Persistent indoor network coverage failure, despite all services working fine claims. Support blockade, preventing profile updates and standard grievance redressal. Complainant/victim, Ranjit Chaudhary, lawful subscriber and owner of device model 2312BPC51H. Accused/offender, Bharti Airtel Limited. Service provider and body corporate. Nodal officer and appellate authority of Bharti Airtel, internal grievance redressal body. Violation of statutory provisions. Section 43, Information Technology Act, 2000, unauthorized access and data damage. Section 66, Information Technology Act, 2000, computer-related offenses. Section 211, Consumer Protection Act, 2019, deficiency in service. Section 247, Consumer Protection Act, 2019, unfair trade practice. Quality of service, QoS, standards under TRII regulations. Violation of constitutional provisions. Article 14, right to equality, protection against arbitrariness. Article 19(1)(g), right to practice profession, occupation. Article 21, right to privacy and digital autonomy. Article 300A, right to property. Article 256, states' duty to ensure compliance with laws. Individuals, non-government, and government institutions involved. Individual, Ranjit Chaudhary. Non-government institution, Bharti Airtel Limited. Government institutions, Department of Telecommunications, DOT. Telecom Regulatory Authority of India, TRAI. Securities and Exchange Board of India, SEBI. Ministry of Electronics and Information Technology, MeitY. President's Secretariat, PG Portal. Prime Minister's Office, PMO. Applicable legal terminologies to strengthen the case. Digital trespass. Data sabotage. Unconscionable contract. Absolute liability. Vicarious liability. Prima facie evidence. Doctrine of proportionality. Promissory estoppel. Deficiency in service. Support blockade. Administrative hijacking. Applicable Supreme Court and High Court orders. Justice K.S. Puttaswamy v. Union of India. Right to privacy. Lucknow Development Authority v. M.K. Gupta. Liability of corporations for consumer harassment. Charan Singh v. Healing Touch Hospital. Commensurate compensation for loss. Arjun Panditrao Kotkar v. Kailash Kushanrao Gorantial. Certification of electronic evidence under Section 65B. Central Inland Water Transport Corp. v. Brojo Nath Ganguly. Striking down unfair/unilateral contract terms. Structural framework for mandatory registration of an FIR. 1. Chronology of admitted cognizable acts. The 19th of February 2026. Cease and desist notice served. Importance. Establishes prior knowledge. Proves the accused acted voluntarily and knowingly under BNS. The 19th of February to the 1st of March 2026. Persistent unauthorized device control. Importance. Establishes criminal intent, mens rea. Shows continuous digital trespass despite formal protest. The 1st of March 2026. Written admission of system wipe. Importance. Establishes physical act, actus reus. Constitutes a direct confession of the destructive action. The 7th of March 2026. Final admission of 35 gigabytes data destruction. Importance. Establishes quantifiable damage. Confirms the permanent deprivation of digital property. Current date. Ongoing digital trespass. Importance. Establishes continuing offense. Mandates immediate police intervention under BNSS. 2. Violations of statutory provisions, presently in force. Section 66 RW. Section 43, Information Technology Act, 2000. Importance. Primary law for data damage. Makes unauthorized access and deletion a cognizable crime. Section 324, Bharatiya Nagarik Sanhita, BNS, 2023, Mischief. Importance. Replaces IPC 425. Defines the destruction of digital property causing wrongful loss. Section 316, Bharatiya Nagarik Sanhita, BNS, 2023, Criminal Breach of Trust. Importance. Replaces IPC 406-409. Addresses the misuse of entrusted access to the device. Section 61, Bharatiya Nagarik Sanhita, BNS, 2023, Criminal Conspiracy. Importance. Replaces IPC 120B. Targets the collusion between software protocols and service execution. Section 329, Bharatiya Nagarik Sanhita, BNS, 2023, Criminal Trespass. Importance. Applied to digital property. Unauthorized entry and retention of administrative control. 3. Violations of constitutional provisions. Article 19(1)(a). Freedom of speech and expression. Importance. Disabling the clipboard and deleting 35 gigabytes of communication data is a direct obstruction of digital expression. Article 21, Right to privacy. Importance. Protects digital autonomy. remote administrative control, is a fundamental breach of personal liberty. Article 300A, right to property. Importance. The mobile device and the 35 gigabytes of data are private property. Deprivation without law is unconstitutional. Article 14, right to equality. Importance. Protects against corporate arbitrariness. Prevents the high-handed imposition of unconscionable tech locks. Article 19(1)G, right to profession. Importance. The loss of professional data and restricted hardware functionality obstructs the right to earn a livelihood. Article 256, administrative compliance. Importance. Mandates that the state, police (DOT) must ensure private entities comply with union laws, IT Act. 4. Binding legal mandates, BNSS and Supreme Court. Section 173, Bharatiya Nagarik Suraksha Sanhita, BNSS 2023. Importance. Replaces CRPC 154. Mandates FIR registration for cognizable offenses, even via electronic means. Section 63, Bharatiya Saksha Adhiniyam, BSA 2023. Importance. Replaces Evidence Act 65B. Validates the admission emails of March 1st and 7th as primary proof. Lalita Kumari vs. Govt of UP 2014. Importance. Absolute mandate. Police cannot refuse FI registration if the complaint discloses a cognizable offense. 5. Mandatory legal terminology for FIR enforcement. Ex facie disclosed commission. The crime is self-evident from the written admissions. Ministerial duty FIR registration is a clerical obligation of the SHO, not a choice. Digital sabotage, intentional, remote destruction of the user's data environment. Administrative hijacking, illegal takeover of private hardware functions. SIM clipboard. 6. Accountability and oversight queries. Compliance hammer. Query 1. Legal justification for excluding Section 66 IT Act despite written confessions. Query 2. Officer identification for classifying digital trespass as civil, despite BNS provisions. Query 3. Status of compliance with BNSS, time-bound inquiry limits. Query 4. Recorded reasoning for ignoring constitutional breaches of Articles 19(1)A, 21, and 300A. 1. Chronology of facts supporting mandatory FIR. To ensure a foolproof filing, the following sequence of facts from your records must be emphasized to establish the nature of the offense. Fact of unauthorized access. The Airtel exclusive app asserted administrative control over a private device, disabling hardware. SIM2/clipboard. Fact of data destruction. The remote deletion of 35 gigabytes of data, admitted by the respondent on March 1st and March 7th, 2026. Fact of intent. Mens rea. The respondent continued the restriction and data suppression despite the cease and desist notice, dated February 19, 2026. Fact of admission. The respondent's written admission that the data is permanently lost and was an unfortunate incident during their forced setup. 2. Request for detailed order. Conceptual terminology and SC mandate. When requesting a detailed order from a magistrate under Section 156(3) CRPC or a senior police official, you must use these terms to trigger mandatory action. Concept of disclosed commission. If the complaint describes ingredients of an offense, the officer has no discretion. They cannot perform a quote, mini-trial before registering the FIR. Reasonable suspicion versus credible information. Under Section 154 of the CRPC, the police only need information disclosing a cognizable offense, not proof at the entry stage. Supreme Court Order. Lalita Kumari vs. Govti of UP. The court held that the provisions of Section 154(1) of the Code are mandatory, and the officer concerned is duty-bound to register the case. 3. Cognizable offenses in the Airtel case. The following sections applicable to your case are cognizable, meaning police must arrest/investigate without a warrant and file an FIR. Section 66 of the IT Act. Computer-related offenses involving dishonest or fraudulent acts, linked to Section 43. This is a cognizable offense. Section 425, 426, IPC, Mischief. Causing the destruction of property, data, or diminishing its value. Section 406 IPC, Criminal Breach of Trust. Since the device was under their administrative control for a specific service purpose, and they used that trust to destroy data. 4. Supreme Court mandate for mandatory FIR, Lalita Kumari case. The Constitution Bench of the Supreme Court in Lalita Kumari vs. Govt of UP 20142 SCC1 laid down the following foolproof rules. Mandatory registration. Registration of FIR is mandatory under Section 154 of the Code if the information discloses commission of a cognizable offense. Preliminary inquiry. A preliminary inquiry is permitted only to see if the offense is cognizable, not to verify the truth of the information. Time-bound inquiry. If an inquiry is conducted, it must be completed within 7 days. Action against officers. The court directed that strict action must be taken against erring officers who do not register the FIR if information received by them discloses a cognizable offense. 5. RTI for explanatory order on section omission. If the police or a regulatory body issues an order that omits the specific sections you cited, e.g. IT Act, Sec 66, or Art 21 violations, you should file an RTI with the following specific queries. Query on deviation. Provide the specific legal reasoning or the speaking order recorded in the file for the exclusion of Section 66 of the IT Act 2000, despite the complainant providing written admissions of data loss from the respondent. Query on constitutional oversight. Provide copies of the legal opinions sought by the department regarding the violation of Article 21, right to privacy, as established in the Puttaswamy judgment in relation to this complaint. Query on noncompliance. Provide the name and designation of the officer responsible for deciding not to treat the unauthorized administrative control as a cognizable digital trespass under the IT Act. Strategic note for Attempt 24. In your communication to the police commissioner, explicitly state, asterisk, as per the mandate in Lalita Kumari versus Govt of UP, you are legally bound to register this FIR, as the facts disclose a cognizable offense under Section 66 of the IT Act. Any further delay or preliminary inquiry into the truthfulness of the data loss, already admitted by the accused, will be treated as contempt of the Supreme Court's directions. It specifically integrates the Bharatiya Sanhita, BNS for offenses, Bharatiya Nagarik Suraksha Sanhita, BNSS for procedure, and Bharatiya Saksha Adhiniyam, BSA, for evidence, alongside your critical constitutional and precedent-based requirements. 2. The Station House Officer/Competent Authority. Dwarka Sector 11 Police Station. New Delhi. Subject. Reminder 2. Mandatory registration of FIR. Cognizable offenses under BNS IT Act and constitutional violations. Attempt number 24. Reference. 1. Detailed representation dated the 11th of March 2026. 2. Written admissions by accused, Bharti Airtel, dated the 1st of March 2026 and the 7th of March 2026. 3. Mandatory directions in Lalita Kumari versus Govt of UP, 2014. 1. Chronology of admitted COGNIZABLE acts. The 19th of February 2026. Cease and desist notice served. Establishes prior knowledge. Proves the accused acted voluntarily and knowingly, satisfying the requirement of mens rea, criminal intent. The 19th of February to the 1st of March 2026. Persistent unauthorized device control. Demonstrates continuous digital trespass despite formal notice. Confirms intentional interference with private property. The 1st of March 2026. Written admission of system wipe. Establishes actus reus, a direct written confession of the destructive activity by the accused's appellate authority. The 7th of March 2026. Final admission of 35 gigabytes. Data destruction. Confirms quantifiable damage. The permanent and irreversible deprivation of digital property. Current date. Ongoing digital trespass. Confirms a continuing offense of unauthorized hardware hijacking, SIM2/clipboard, requiring immediate FIR registration under Section 173 BNSS. 2. Violations of statutory provisions, in force. Section 66, read with Section 43, IT Act 2000, unauthorized access and fraudulent data deletion, classified as a cognizable offense. Section 324, Bharatiya Sanhita, BNS, 2023, Mischief. Digital property destruction causing wrongful loss to the complainant. Section 316, Bharatiya Sanhita, BNS, 2023, criminal breach of trust. Misuse of entrusted administrative access to the device for destructive purposes. Section 61, Bharatiya Sanhita, BNS, 2023, criminal conspiracy. Collusion between software automated protocols and service execution to bypass user consent. Section 329, Bharatiya Sanhita, BNS, 2023, criminal trespass. Unauthorized entry into and retention of administrative control over a private digital domain. 3. Violations of constitutional provisions. Article 19(1)(a), freedom of speech and expression. The forced deletion of data and disabling of the clipboard is a direct obstruction of digital communication. Article 21, right to privacy. Unauthorized remote control is a gross violation of digital autonomy as per the Puttaswamy judgment. Article 300A, right to property. The mobile device and 35 gigabytes of data are private property. Their deprivation without due process of law is unconstitutional. Article 14. Right to equality. Protection against arbitrary and high-handed corporate or technical actions. Article 19(1)(g). Right to profession. The destruction of professional records and restricted hardware functionality obstructs the right to livelihood. Article 256. Administrative compliance. The state's duty to ensure private entities comply with union laws, IT Act, BNS. 4. Binding legal mandates and judicial precedents. Section 173, BNSS 2023, explicitly mandates the registration of an FIR for cognizable offenses. Refusal constitutes a dereliction of ministerial duty. Section 63, BSA 2023, validates that the accused's admission emails, the 1st of March and the 7th of March, qualify as primary evidence of the crime. Lalita Kumari versus UP, 2014, SC. FIR registration is mandatory when a complaint discloses a cognizable offense. No preliminary inquiry into the truth is permitted at this stage. S.N. Mukherjee versus Union of India, 1990, SC. Administrative orders affecting rights must include detailed reasons. The absence of a reasoned order indicates arbitrariness. Maneka Gandhi versus Union of India, 1978, SC. Denial of procedural fairness violates Article 21. Reasoned orders are a prerequisite when fundamental rights are affected. 5. Legal terminology for enforcement. Ex facie disclosed commission. The crime is self-evident from the accused's own written admissions. Ministerial duty. FIR registration is a clerical, non-discretionary obligation of the SHO under Section 173 BNSS. Administrative hijacking. The unauthorized and hostile takeover of private hardware/software functions. 6. Accountability and compliance queries, for the record. 1. Provide the legal justification for excluding Section 66 IT Act, despite the accused's documented confessions of data loss. 2. Identify the officer responsible for classifying digital trespass as a civil matter in contradiction of the BNS and IT Act. 3. Provide the status of compliance with the BNSS time-bound inquiry limits for this complaint. 4. Provide the recorded reasoning for ignoring constitutional breaches under Articles 19(1)(a), 21, and 300(a). 5. Provide a speaking order detailing the acceptance or rejection of each statutory section requested, as mandated by S.N. Mukherjee versus Union of India. 7. Legal imperative. The registration of this FIR is not a matter of discretion, but a statutory and constitutional imperative. Refusal or delay in registration constitutes a direct violation of the Supreme Court's mandate in Lalita Kumari and S.N. Mukherjee. Such failure will be treated as intentional arbitrariness and may be challenged via a writ petition under Article 226 or a formal complaint for dereliction of duty. 8. Prior delation directions sought. 1. Immediate registration of FIR for all cognizable offenses mentioned above. 2. Disclosure of a reasoned speaking order for the acceptance or rejection of each section cited in this representation. 3. Investigation to proceed as per BNSS and IT Act 2000 with strict, time-bound compliance. 4. Accountability for any further refusal or delay in the performance of ministerial duties. Based on the Bharatiya Nagarik Suraksha Sanhita, BNSS 2023, and the Lalita Kumari mandate, once a police officer receives information of an offense, the investigation must structurally verify the following elements to sustain an FIR. Investigative parameters for FIR registration. Offense committed. Determination of whether the act is cognizable, arrest without warrant, or non-cognizable. Identification of the specific harm, e.g., data destruction, digital trespass. Applicable act and section. Mapping the act to BNS 2023, e.g., Section 324 for Mischief, Section 316 for CBT. Mapping to special laws like IT Act 2000, e.g., Section 66 for data damage. Intent, mens rea. Verification of voluntary, knowing, or reason to believe actions. Evidence of ignored warnings, e.g., the February 19th cease and desist notice. Proof, actus reus, and evidence. Physical act, the execution of the system wipe. Documentary proof, admission emails from the accused, March 1st and 7th. Digital proof, system logs showing administrative control under Section 63 BSA 2023. Jurisdiction, locus standi. Verification that the crime occurred within the police station's territorial limits or affected a resident therein. Mandatory reasons for police to register FIR. Refuting common grounds for rejection used by officers. 1. Disclosure of cognizable offense. If the information shows a cognizable crime, the officer must register as per Section 173 BNSS. 2. Admission of accused. When the accused admits the act, as in the 7th of March email, the reliability of the information is already established. 3. Mandatory compliance. For Lalita Kumari, police cannot perform a mini-trial to judge the case's merits before filing the FIR. 4. Electronic record duty. Under the new BNSS, information received via electronic communication, emails, PDFs, must be taken on record immediately. Section 12. List of authorities and addresses to content. 1. The HONBLE, President of India, Head of the Republic, Rashtrapati Bhavan, New Delhi 110004. 2. The HONBLE, Prime Minister of India, Head of Government, Prime Minister Office, PMO, South Block, New Delhi 110011. 3. The Cabinet Secretary, Government of India, Administrative Head, Cabinet Secretariat, Rashtrapati Bhavan, New Delhi 110004. 4. The Union Home Secretary, Ministry of Home Affairs, MHA, for Cyber Trespass, National Security, North Block, New Delhi 110001. 5. The Secretary, Ministry of Electronics and Information Technology, MIETI, for Information Technology Act-related matters, Electronics, Niketan 6, CGO Complex, Lodi Road, New Delhi 11003. 6. The Director General, Indian Computer Emergency Response Team, CERT-IN, for examination of data, sabotage, and device control-related cyber incidents, Electronics, Niketan 6, CGO Complex, Lodi Road, New Delhi 11003. 7. The Secretary, Department of Telecommunications Licensing Authority, Sanchar Bhawan, 20 Ashoka Road, New Delhi 110001. 8. The Chairman, Telecom Regulatory Authority of India Sector Regulator, Mahanagar Doorsanchar Bhawan, JL Nehru Marg, New Delhi 110002. 9. The Chairman, Securities and Exchange Board of India, for Corporate Governance and Listed Entity Compliance, SEBI Bhavan, BKC, Mumbai 40051. 10. The Chief Executive's National Stock Exchange of India, Exchange Plaza C1, Block G, Bandra Kurla Complex, Bandra E, Mumbai 400051. 11. The Chief Executive's Bombay Stock Exchange, for listing compliance, Firoz Jijibhoi Towers, Dalal Street, Mumbai 400001. 12. The Governor, Reserve Bank of India, for Airtel Payments Bank and Financial Compliance Central Office Building, Shahid Bhagat Singh Road, Mumbai 40001. 13. The Secretary, Ministry of Corporate Affairs and Registrar of Companies, ROC, for Director Liability, Shastri Bhawan, Dr. Rajendra Prasad Road, New Delhi 110001. 14. The Commissioner, Central Consumer Protection Authority, for Unfair Trade Practices, Krishi Bhawan, New Delhi 110001. 15. And all other competent statutory authorities having jurisdiction over the matters stated herein.